The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
I'm Vinnie Politan. The subject of my investigation is the death of Boston police officer John O'Keefe. He was found dead in a snowstorm on another officer's front yard after a late-night party, but no one at the party was investigated because police said John's boyfriend, Karen Reed, killed him. Here's the story. Karen Reed, accused of the January 2022 death of her boyfriend, Boston police officer John O'Keefe, has consistently asserted her innocence, alleging a concerted effort by law enforcement to frame her. She contends that John O'Keefe was fatally injured inside a residence and that authorities manipulated evidence to implicate her. Central to her claims is the conduct of lead investigator Trooper Michael Proctor, whose inappropriate text messages and close ties to key witnesses have raised questions about investigative impartiality. Proctor faced disciplinary action due to these concerns. Reed's defense maintains that systemic biases compromised the investigation. Her first trial concluded in a mistrial, with the jury unable to reach a unanimous verdict. And now the community prepares for the retrial of the century. We're getting closer and closer. Now, the part of this trial that makes it so unique, the public support obviously is a huge part of it, but it's what drove that public support, which is a completely alternative theory about the death of John O'Keefe. We're talking about the defense saying, listen, Karen Reed, this wasn't an accident, this wasn't a murder, no. Someone else did this. Someone else in that house did this. And I say that because during the course of the first trial, there was a piece of evidence brought in by the defense, and it was a video from inside 34 Fairview, the home where the party was, and it's in the basement and then exits the basement. Let's take a look. Here, they're opening up what do they call it, the bulkhead latch from outside, and there's some stairs down there, and those stairs go into the basement. Now, if you go up those stairs, out of the basement, backyard to the fence, and you open up the door to the fence, and then you walk forward on the yard, it will take you almost precisely to where John O'Keefe was found dead. There you can see the flagpole, the fire hydrant, that whole area. That's where John O'Keefe was found. So that evidence brought in to demonstrate, I guess, how John O'Keefe could have been removed from the home and placed onto the front yard. But that's kind of like the tail end of everything, which brings us to the first question in our investigation, which is, what exactly, and that's the key word here. I know conspiracy, cover-up, frame, all of that, but what exactly is the defense's theory? And it's the theory of the death of John O'Keefe. Like, how does he die? Who does it? Let's talk about it. Let's bring in Karen Reed supporter and creator of the Justice for Officer John O'Keefe and Karen Reed Facebook page, Nick Rocco, and YouTuber and author of the book Storm of Suspicion, The Karen Reed Trials. Kevin Lenahan is with us. Great to see you both. Let's talk about this. All right, Nick, let's try to understand this, right? So the theory is that John O'Keefe goes into the home what happens? What is the theory? What is the basis or the working theory of how John O'Keefe died?
Well, I don't speak for the defense team, but if what I'm following along is basically John O'Keefe goes inside the house, words are exchanged, and a fight breaks out. I think the defense team believes it was downstairs in the basement, and obviously it was a fight gone wrong where you have that fatal blow to the back of John O'Keefe's head. Now, I don't think they've specifically said what they believe had caused it, whether it was the ground, a fist, a weight. And then obviously, while this fight is breaking out, you have Chloe, the dog, that is attacking John's arm while this is going on. And I believe the reason why they're showing this bulkhead is because that's the only exit out of the basement, which would make the most sense as to, why potentially some of the people upstairs are saying, oh, we didn't see John, or, people are saying he never came inside the house. I don't think they're saying that he entered that way. I believe they're saying that that's the way that he came out of the house and then obviously brought onto the front yard. Obviously, you have a lot of coverage being in the backyard, so it's a short distance from that fence to the flagpole. But I believe it's pretty simple of a theory that a fight, broke out and it turned bad. And, Judge Beverly Cannoni had made them name names. I don't believe the first time that they named the names, but she did make them name the names this time, and they named Colin Albert, Brian Higgins, and Brian Albert. So it's going to be interesting to see what they put forward this time, but I believe it's going to be pretty similar.
Let's take a listen to that hearing on third-party culpability.
We're solely seeking to introduce the crux of a third-party culprit defense, which is evidence of motive, opportunity, and means, all of which Brian Albert, Brian Higgins, and Colin Albert had.
We see in their motion there's a grand claim that there's extraordinary evidence that John O'Keefe went into 34 Fairview that night. That is critical. We didn't hear any evidence. We just have the bald assertion that the data forensic evidence will show that he was in the house. It didn't. It doesn't. They don't have a proffer. So there is no opportunity to murder John O'Keefe when all the evidence points to him dying on the front lawn from an alleged collision.
Okay, Kevin, what are your thoughts here when we talk about this defense theory? A fight breaks out, right? Coming into the house. What do we know about the entrance to the house, the entrance to the basement, and where Brian Higgins, Brian Albert were? We're taking a look at them right now. And this was evidence also doing some shadow boxing at the waterfall that night. What do we know about the entrance to the house and how you would get down to that basement?
Well, I think what you're doing now is exactly what they don't want the jury to do, which is to try to really dig down and find the specifics of their theory. They don't want that at all. What they want is they want to get the jurors to say, well, what about this and what about that? The key thing is throw a bunch of stuff out there that looks a little weird, like butt dials or whatever, and keep them distracted in that way. And that way they won't zero in on the key evidence. So the key evidence shows that John's phone, at least, never went inside the house, period. There's no way to argue that it did. So now you're stuck with a theory of John going in the house without his phone and his phone ending up underneath his body at the far edge of the property. There's no evidence on John's body that he was in a fight. The emergency room doctors testified to that, as did the medical examiner. There's no scuffs on his hands. He doesn't have a split lip. Doesn't have a broken nose. He doesn't have any signs on his face. There are 2 tiny scratches on his face. That's it. So John was not in a fight. Now, somebody could have, ambushed him and whacked him on the back of the head. So if there was no fight, that would be the only way. But it gets more and more preposterous when you think about it. The idea that these people lured, to use the words of defense during the trial, lured, and ambush is another word they use, for reasons unknown. None of them have any there's no friction at all between the Alberts and the McCabe's and John O'Keefe, nothing. They lure them back to the house where their kids are, where their son is having a birthday party, where there are women, and they invite their daughter back to do this. What? So they could attack him in the basement and then foolishly drag him out, still alive, to leave him on their own lawn when they could have just went a few feet further and put him in the street or put him in the next yard. But they don't want people thinking about this stuff, because when you think hard about any of the claims in this conspiracy theory, it falls apart completely.
Nick, what are your thoughts about the phone and any bad blood between the parties here?
Well, I mean, Karen Reed's phone doesn't show that she went up 3 flights of stairs, but John O'Keefe's phone shows that he went up 3 flights of stairs. And the GPS is not always 100% accurate. I mean, you can look at your phone right now, and it might show you that you're on the front lawn, and then eventually it moves around a little bit here and there, and then might find exactly where you are. So it all depends on the service in the area as well. And we know that Brian Higgins, Brian Albert, and the rest of them had said they don't get really good cell service over there. So then, especially if you have clouds in the sky, you got snow falling down, that's going to interrupt GPS signals. So, you know, I think one of the biggest things that, you know, Kevin is stuck on is that GPS data. But how do you explain John O'Keefe driving on a flat road all the way from the bar to 34 Fairview Road, and only his phone registers 3 flights of stairs, but not Karen Reed's? And I know they say, oh, well, her GPS data was shut off and this and that, but they took custody of her cell phone shortly after, and it shows that, you know, nothing was done. She didn't delete anything off her phone. It's the biggest thing is the flights of stairs.
I'll give you 15 seconds, Kevin, before we run out of time here.
Thank you, Vinnie. Nobody on either side has presented any data from the health app on Karen's phone, so we don't know what that showed, which is a little unusual, right? But the GPS is, we always know the lack. We know the signal strength continuously from second to second. So if there's any loss in signal, that's measurable for every particular second, and it shows that John never went in the house.
All right, Nick and Kevin are going to stay with us. Coming up next, will the defense say she was framed in the retrial?
You will reasonably doubt their case because their theory of the case does not make sense.
The Court TV podcast will return.
You will reasonably doubt their case because their theory of the case does not make sense. You will reasonably doubt their case because Karen Reed was framed, and the evidence shows that, despite the fact that the police never ever investigated that angle of this case at all.
We're getting close to the opening statements in the retrial of Karen Reed, but I want to go back to the opening statements in the first trial, the first moments of that first trial. And it was big and it was bold, delivered by Karen Reed's attorney, David Yannetti.
Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death. And that means that somebody else did. You will learn that it was no accident that John O'Keefe was found dead on the front lawn of 34 Fairview Road in Canton on January 29th of 2022. You will learn that at that address lived a well-known and well-connected law enforcement family in Canton, the Alberts. Because the Alberts were involved, and because they had close connections to the investigators in this case, Karen Reed was framed for a murder she did not commit.
It was big, it was bold. Brings us to the next question in our investigation. And it's all about the second trial. Will the defense say she was framed in the retrial? Will they come out of the gates the same way they did in the first trial? Here with us, longtime Massachusetts attorney, was a prosecutor for 20 years, including homicide chief in Norfolk County. And yes, was the prosecutor in the first case that I covered as a correspondent at Court TV. Rick Grundy is with us. And Boston attorney, former prosecutor. She's followed this case closely. And she's Note My Objection on TikTok and has had intense coverage of this case. Catherine Loftus is with us. Great to have you both here. All right, Rick, what do you think? What do you think? Are they coming out of the gates the same way? She was framed.
Well, you know, they're not coming out of the gates the same way because they already went to the bullpen. And my understanding is that Mr. Jackson will be giving opening statement this time and not Dave Yannetti. So what is that signal? I don't know. But you and I, Vinnie, had the opportunity, which I'm sure you remember, it's a treasure in your memories, of speaking that night about the opening statements and how the prosecution really came out flat, on the defensive, meandering. And Dave stepped up there, Attorney Yannetti stepped up there, and right off the bat, she was framed. And it was, as you said, it was bold, it was gripping, and it's overshadowed the opening statement of the prosecution. But fast forward to verdict time, or lack thereof, and one of the things that we heard from a juror was, I think, very telltale, and that was, we just didn't know what happened. Well, if you present your case in one manner and they listen to those instructions, we don't know what happened equals not guilty. And we talked about it that night of the first opening statement, that it was bold, but you take those scales where the Commonwealth has to prove it. This is the burden of proof. And the defense is way down here. And in a juror's mind, when you tell them, not only does my client not guilty, we're going to tell you what really happened, that starts to level off right away. And that leads to somebody saying, well, if I can't pick either story, then maybe I'm deadlocked. As opposed to, if you can't pick one story, then the Commonwealth has not met its burden. It's 100% on them. Not knowing what happened at the end of the trial is a not guilty. So that's what the defense has to think about. Did we come out too hard, too strong? And do we go back to that stalwart defense argument? They cannot prove this case against my client.
All right, Catherine, what are you thinking? What do you think is going to happen inside that Dedham courthouse?
Well, first, Vinnie, thanks for having me on tonight. I have to agree with my brother. One of the things that I noticed first when they gave, David Yannetti gave his opening statement was the fact that he used the word framed. Now, we all knew that there was going to be the presentation of the third-party culprit theory, but given the court's ruling that it was not to be addressed in opening, it certainly was a shock for many of us. And I think what Attorney Grundy is essentially stating is exactly what happened with the jury, that in a way, despite the fact that we all know that the defense does not have to prove anything, it's the Commonwealth's burden to prove their case beyond a reasonable doubt. Essentially, they really burden shifted when David Yannetti came out with this claim that Karen Read was going to be they were going to show that she was framed. And then it wasn't really clear who exactly did it and which people were participating in the framing. And when we heard subsequently after the mistrial was declared from the jurors, essentially it seemed like they narrowed it down to two binary choices. Either Karen Read was guilty and hit John O'Keefe with her vehicle, or she was framed, and there really was no room left in the middle. And in this case, there is a lot of room to argue in the middle, and I think that's really where the defense will focus this time. Obviously, they're still going to be presenting the defense of the third-party culprit, but I think it will be a little bit more intertwined with the lack of the standard police investigation. Here in Massachusetts, we have what's called a Bowden defense, which essentially states that the jurors can consider any omissions in the police investigation, or if it was substandard, and they can use that in their deliberations.
Or if the lead investigator gets fired, can they consider that?
That's exactly right. And so that's why I think there is so much in the police investigation for them to focus on that, in a way, prioritizing the third party and the framing of Karen Read in the first trial was almost a bit of a distraction to the jury, and they felt like maybe the defense didn't follow through on who did it. You know, if you tell somebody this person's framed, they want to know who is it that did the framing, and we want to be able to hold somebody responsible. And because they weren't able to get to that point, they seem to have gone back to the other side, which was the Commonwealth's perspective, and that's not where the defense wants the jury to be focused. So I think they'll lessen the verbiage a little bit this time around and focus a little bit more on the reasonable doubt.
Let's take a look here at some of the police testimony relative to the broken pieces of the tail light, because that's a big part of the framing theories, that they're literally planting evidence and taking pieces off of Karen Read's tail light.
I found multiple pieces of red and clear taillight. They were on the street in between the flagpole and the fire hydrant. I believe maybe 6 or 7 pieces. There was 3 larger pieces, 2 red, 1 clear, and then a couple of smaller pieces.
So do you think the taillight pieces being placed at the scene, how do you think they will attempt to demonstrate that that is possible again, Rick?
I think, I think this is the kind of thing that that we were just talking about.
Rick has frozen. Catherine, you're up.
I think they will focus on the taillight pieces because really, Vinny, I think that from my perspective, it's the most important piece of evidence because in order for the third-party culprit theory to have any weight, the taillight pieces essentially have to be planted, right? Because what is the alternative? If they're not planted, then the next natural inference for the jury to glean is that, well, somehow those pieces got there, and if they weren't planted by the police officers, the logical conclusion is that they're Karen Reed. So the defense's job is to be able to put together a timeline in which it's theoretically possible that whether it's Michael Proctor that they're accusing or some other party, that at least there is the possibility that those pieces could be planted, because if they can't raise that sort of question of whether those pieces actually got there via Karen Reed's vehicle or not, it's really the crux of the case, I think.
All right, Catherine Loftus, Rick Grundy, you're going to stay with us. Up next, what do the driveway videos reveal?
Now, back to the Court TV podcast.
I'm Vinnie Politan. We continue our investigation of the death of Boston police officer John O'Keefe. His girlfriend, Karen Reed, is accused of running him over, but she says she was framed by police. Here's the story. In the early hours of January 29th, 2022, Boston police officer John O'Keefe was found unresponsive outside a residence in Canton, Massachusetts during a harsh snowstorm. He later succumbed to injuries consistent with blunt force trauma and hypothermia. Authorities swiftly turned their attention to his girlfriend, Karen Reed, alleging she struck O'Keefe with her SUV and left him to perish in the cold. Reed was subsequently arrested and charged with second-degree murder. The courtroom became a focal point of intense public interest during Reed's initial trial. Supporters gathered outside the Norfolk Superior Court in Dedham, passionately advocating for her innocence. The scene was marked by fervent chants of "Free Karen Reed," creating a charged atmosphere that underscored the case's emotional gravity. Inside, tensions flared as the trial concluded without a verdict, leading to a mistrial and setting the stage for the retrial of the century. Yes, it's going to happen. It's going to happen. It's like exactly 1 year later, this trial will be held again in Norfolk County, in the Dedham County Courthouse, with everything at stake. The only difference is, I think, everything has been heightened. I mean, as intense as that first trial was, the fact that the first one was a deadlock jury and there was controversy about that deadlock has just increased everyone's passion and position in all of this, especially inside the courtroom. Now, let's talk about some of the videos. I want to show you a video. This is John O'Keefe on moving his vehicle before going out on January 28th, 2022. Everyone in town knew there's a snowstorm coming in. So he's moving his vehicle to a spot so Karen Reed can get in and I guess out of that garage. So you're seeing the cars being moved in the driveway, and you'll see John pull back and then pull into the spot. And that's the spot. It's significant because of another video from that same camera. But this is probably I guess the last video of John O'Keefe at home. So it's not the only video. There are others from that camera on the driveway. And that brings us to the next question in our investigation. What do the driveway videos reveal? What do they show us? This is one of those stories, one of those cases where nothing is 100% clear. Even the videos are up for interpretation. So let's bring in our guests with us. Karen Reed supporter, creator of the Justice for Officer John O'Keefe, and Karen Reed Facebook page, Nick Rocco, and YouTuber and author of the book Storm of Suspicion, The Karen Reed Trials, Kevin Lenahan. Okay, let me start with the one we always talk about, but it's significant. This is Karen Reed backing up her SUV. This is at 5:08 a.m. Nick Rocco, what is significant from your perspective about this video?
Well, she obviously strikes John O'Keefe's vehicle, and we can see the taillight right now. It does not look to be the same way that the Massachusetts State Police is presenting it with their pictures and their theory of the case, that all 47 pieces of red taillight was off of her vehicle. You can see it right here. There is red still illuminating. It's the same image as it was a few days before January 29th. We know that pieces broke when she hit John's taillight. I know Kevin has mentioned before, well, there's no taillight in the snow on the driveway. That's because it could have got pushed into the housing. So when Karen Reed said she pulled pieces out, it could have been the pieces that got knocked into the housing. So it's interesting, though, how she said she had, puts them in the driveway. But when the state police put her red taillight all back together, correct me if I'm wrong, but I don't believe any pieces were missing when they reconstructed it. It was fully intact when they reconstructed it.
Kevin Lenahan, what are you seeing in this video?
Well, first of all, I don't believe it was fully reconstructed, Nick. We'll have to go back and check, but I think it was maybe 95% reassembled. Clearly, if you look in that spot, there's other angles, but this is a good angle here, Vinny. You can see that corner piece is what's missing. And if you zoom in on it, you can see it's kind of similar to the shape to what we see later in the Sally report. Interestingly, the defense showed similar video, but from a slightly different angle in the closing arguments of the first trial, and said that this is just cracked. This is not missing pieces. But now Nick and everybody finally admits, okay, we were wrong. It was missing pieces. It just doesn't miss them in quite the same way that we saw before. So it's clearly missing pieces. There's nothing that fell in the snow there. The vehicle backed into John's Traverse at a very, very low rate of speed, just bumping it. In fact, I think even the ARCA guys, Dr. Renshaw, if I remember, testified that wouldn't have been enough to cause any damage. So the idea that this is where Karen's taillight was actually damaged, it's just a no-go.
Let's take a look at another video. This is from the driveway. Again, same camera. Let's take a look. Nick, what are you seeing here? What is significant?
Well, this was the morning after everybody had left the hospital. You have Karen's vehicle there. John's vehicle, obviously, is still in the same spot. And then I believe that is her brother, Nathan, getting into the vehicle behind her. I don't know where Karen went. She may have gone into her car, but you really can't see her taillight in this position. You see that it's snowing out, but I don't know what the relevance to this would be to prove that her taillight was still intact or broken at this point. I know you have people, there are other people that also come into the house, I think might have been before this or later after this video, and nobody is looking directly at her taillight and being like, oh my God, look at that thing. It's missing all these pieces. What happened? So I think the fact that when people were walking by and they didn't specifically see that, even because they had to have looked at it when they walked by her vehicle, would also raise concern of why wasn't she questioned at that point?
Kevin, anything in that video significant?
If you play a little further, you'll see Karen's brother, Nathan. He goes and when they're going to take the vehicle home, and he cleans it off. And he cleans off the taillights, but he specifically avoids touching the damaged taillight. So he clearly noticed something there, and he didn't want to touch it. So, another thing about this video here is this is the angle that we should see because that's where it was parked by Jen McCabe when her and Kerry and Karen went out looking. And right before they went to leave, Karen has described the same way as Kerry and Jen have described, the three of them examining that taillight. And this is what Karen says she plucked out a piece and dropped it on the driveway. But that ring video is missing, along with a couple of other ones that are missing. Now, we don't know who deleted them, but the only one that would have had any incentive that anybody can point to is Karen, because she seems to have deleted videos, or the ones that are missing are ones that would potentially show her examining the taillight, and especially the one of her getting home at around 5:36 in the morning. I'm sorry, 12:36, right after striking John. If that was that video is missing, so if that video showed her going out to look at that damage, then she would know at that time that she struck something, and she took no action to try to help John. So that would be crucial for second degree.
Let's take a listen to Sergeant Buchanan talking about the missing videos.
The data returned had video that would have been captured from the defendant arriving home after midnight on the 29th, after she dropped Mr. O'Keefe off at 34 Fairview Road. That video was not present in the data that was returned from Ring.
What, if any, other video in addition to that one was not present?
There was also video missing from the defendant showing Ms. McCabe and Ms. Roberts the damage to her right rear taillight.
All right, Nick, what are your thoughts about the two missing videos, the significance of that, and who had an opportunity to erase them? How would it be done?
So I believe it was the niece and nephew that testified that said Karen didn't have access to get into his Ring footage. You could either get it through the computer or on the phone. John's phone was on him, and Karen obviously couldn't have access to the phone. And then in the computer, I mean, her only time that she would have been able to do it, where they said she went upstairs for about 15 minutes, but that was to gather her belongings. So I don't think it would have been at that point. I don't think she deleted anything personally. I think either it wasn't captured or potentially it got erased. But I mean, I believe there's a Ring person on the, I don't know if it's the defense's witness list or the Commonwealth's witness list, but there is going to be somebody from Ring that testifies. So they're going to be the best ones to clear this up for everybody. So Kevin, I mean, it's significant. If someone purposely deletes videos, whoever it is, it's a big deal. But I don't think we've had that established. It just seems like some digital footprint should have been made.
Right. Yeah, it's a mystery right now. Karen is the only one that we know of that would have any incentive to want to delete those, but that's not enough to prove that she did it. In terms of where she could have done it, it could have been done from any browser as long as you had John's sign-in and his password. Now, we have no evidence that she had those things, but would it be that unusual for a girlfriend to have that from her boyfriend? No, I don't think so, but we don't know. It's definitely not proved. The only thing we know is, suspiciously, those videos are missing, and it's hard to imagine why the state police would have had any incentive to want to delete those, but we understand why Karen would want to delete videos showing her examining the broken taillight.
Nick, is there any potential for anyone from law enforcement wanting those videos deep-sixed?
Well, I mean, the thing is even if she was showing Jen McCabe and Kerry Roberts her taillight, that would have been after the fact of her backing into John's vehicle. So the only thing that, if there was a video that was deleted that would be important would be her coming out, basically arriving back home from 34 Fairview Road with a broken taillight. Any crack or missing piece after that point, even if it was deleted, wouldn't really be relevant because we know that she cracked it from striking John's vehicle. So I don't know because I mean, Kerry testified about it and Jen did as well. And I believe Karen made a statement about it that she showed them her taillight was cracked. So why say that if you knew you deleted something? You know what I mean? That just doesn't make sense to me. If you're going to tell people that, oh yeah, I took a piece of taillight out, I showed Jenny was cracked or broken, why would she have deleted that? Anything like that.
Nick Rocco, Kevin Lenahan, always great to have your insight, our trial insiders. We'll speak again really, really soon, right? And really often. All right, still to come. Did Judge Cannoni go too far?
This is the Court TV Podcast.
Karen Reed was framed, and the world knows it. We have been subjected to domestic terrorism. We will not be terrorized anymore. Free Karen Reed! Love you, Free Karen Reed!
That's the scene. You have to go there. Like, if you have an opportunity to experience the passion of the people outside, you should do it. You really should do it. It's very unusual. Like, we've never seen this before for this type of case. Like, just two folks from Massachusetts, right? Like, you've seen it in some cases that have some political or some other sort of issue connected to it, but not a case like this of two ordinary folks, a police officer, a college professor, and that passion at the courthouse. But there were limitations on what they could do, what they could wear, where they could be. Take a look at the last trial. The supporters, the protesters, however you want to describe them, couldn't get within 200 feet of the court complex. They were pushed down the block. They could sort of see the courthouse from where they were, and there was like an area where Karen Reed would arrive and they would greet her there. And then some of the folks who didn't have signs, they just wore the color pink, would get a little closer to the courthouse. But now there's a new ruling. The buffer zone, which is how they define the area where you can't have signs or cheer or whatever, is extended to the area marked by Bates Court, Bullard Street, Ames Street, and Court Street. And my understanding is it's seemingly doubled or maybe more than doubled the distance. And the folks who are impacted by this are saying, listen, we're now stuck like way down the block and around the corner, and we're like on people's lawns, like residents' lawns, nowhere near the courthouse. So, brings us to the next question in our investigation. With this ruling, did Judge Cannone go too far in limiting the First Amendment rights of the folks who want their voices heard? Here with us, longtime Massachusetts attorney, prosecutor for 20 years, including as a homicide chief in that county, Norfolk County. Rick Grundy's with us, and Boston attorney, former prosecutor, has followed this case closely. She's Note My Objection on TikTok. Catherine Loftus is also with us. I guess they had a situation like this, not for the Grenadier trial, Rick, but maybe the Sacco and Vanzetti trial in that courthouse many years ago. But they also put the defendants in a cage. But that, that was then, this is now. Is this too far, Rick? Is this going too far?
Not at all. Not at all. You need to balance the rights of the individuals here. And no jurors, no witnesses, and officers or defendant, if the tide were differently, should be subjected to this kind of circus atmosphere outside of the courthouse during this. And that was, I think, probably the linchpin to this ruling, was that there was put forth that the jurors, and you've been in the courthouse, Vinnie, you know the setup, the jurors were, in their room deliberating right outside the window, hearing this. That's improper.
Okay, let me throw this at you, Rick. How about silent protesting? You can't scream, but you can hold your signs.
I still think, again, for the people who are passing through this, it's intimidating, whether it be a witness, whether it be a defendant, whether it be a victim's family. They should not be subjected to that when they're going through this particular situation. It needs to be merited out appropriately based on the interests that are here. And, O.J. Simpson just passed away, an innocent man, because a case was allowed to become a media circus. That's the first one that we really
Hey,
saw
don't you blame me, Rick Grundy. He's trying to blame me. Did you see that? You see how he just slid that right in there, Catherine? All right, Catherine, let me ask you, is this the least restrictive manner that she can restrict the First Amendment free speech rights of these protesters?
I think so. If you recall the first time, as you stated, there was a 200-foot buffer zone. And one of the things that she cited to in her order when she expanded this buffer zone and included other things relative to what individuals could wear in court, buttons or, what they could put on signs or things like that, was specifically that the jurors submitted affidavits outlining that they could, in fact, hear outside noise. They could hear protesting, they could hear chanting. And when you have governmental interests in protecting the sanctity of the jury and ensuring that they are fair and impartial, that they are not influenced by any outside information, protesting, things like that. Of course, it's difficult because everybody has a right to free speech, and there's nobody who's more of an advocate for the First Amendment than I am. But ultimately, when we look at the situation between balancing the two, and that Karen Reed is on trial really for her life, she's on trial for a second-degree murder. And as Attorney Grundy said, if this was the converse, if there were numerous protesters outside who were chanting that she was guilty or that she was a murderer, would that affect the jury? Of course it would. So when you look
that
at
was the Casey Anthony trial, and it didn't affect him. I don't know. It's interesting. I'm going to run out of time here. I only have a few seconds, Rick. But I want to ask you, Rick, 15 seconds we have. The protesters who have filed their case against the judge are saying, we're just protesting the judge. So are you bothered by the judge limiting the speech of people protesting her?
Not at all, because first off, I don't think the facts support that accusation. But secondly, she is a representative of the judiciary system. So if you're protesting her, you're protesting the judiciary system. And that was the problem with it from the start. And also that courthouse, on the courthouse steps, the defense attorney and defendant trying their case every day was outrageous. That never should have happened. And that's been put to bed.
Rick Grundy, Catherine Loftus, note my objection. Thank you both so much. We'll be speaking a lot. This trial is unlike anything we've ever seen on Court TV. People cheering an accused cop killer. Supporters being kept away from the public courthouse. One even being charged with witness intimidation. It's divided the community in Massachusetts and the community online, and neither side wants to hear what the other side is saying. But guess what? They'll have to listen to each other once the opening statements begin. I'm Vinnie Politan. We'll keep digging for answers as the investigation continues.
There you have it. If you want to see more in-depth reporting on the latest true crime stories, you can see me every weeknight, 8 p.m. Eastern on Closing Arguments. Thank you so much for downloading. And as always, please don't forget to hug the kids.
This podcast is a production of Court TV. Go to CourtTV.com for more content, trials on demand, and to find out how to watch Court TV in your area.